What is the best way to deal with real estate in your estate plan, especially if you want to leave it somebody like your kids after you pass away? In this video, we are going to go through that. My name is Michael Pevney. I am an estate planning lawyer and I create estate plans for California families. You can follow my account for more estate planning information. I've got a bunch of videos out there, and you can set up a time to meet with me for free if you live in California, and it's time to get that estate plan set up. So let's jump right into it. I'm going to break these down when I'm talking about real estate. On one hand, we have a primary residence, and then on the other hand, we have other property, whether that is commercial real estate, a rental property, a rental home, or even a vacation home. So let's go through first a primary residence. What is the best way to pass things along to your kids, or really whoever you want to pass things along to? What we really want to make sure we do is avoid probate. Remembering that probate is the government-controlled, judge-authorized, state-run asset distribution program, and it can be expensive, it can take a lot of time, and it is not private. So one of the ways to pass things along by way of avoiding this is to actually put the person you want to pass things along to on the deed to the home. Joint ownership can be a way to avoid probate, but it's not the best way. First, it opens you up possible creditors of that other person that you share the property with. So for example, I've got two little kids, two little girls, let's say they're adults. I put both of them on property that I own, child one and child two. If they get sued, that house may very well be up for grabs. So although it would avoid probate, it would avoid court when I pass away if things are owned in a joint tenancy, it does not avoid creditors of the person that owns that property along with me. So that home could be up for grabs, even in a divorce type situation. If we want to protect kids from divorce, that is not a good way to do it, while it does still avoid the probate process. There is also another huge issue there that involves capital gains taxes, where especially if I bought the home for a small amount of money, it's now grown in value because maybe I've been there for 20 or 30 or 40 years. We want to make sure that the people we pass things along to don't have a massive capital gains tax bill once they sell the home after I've passed away. And so joint ownership is not a good way to maximize those benefits. What's another way we can pass things along to the people that we want things to go to? We can have a will. A will, of course, tells people when we pass away where we want things to go. And we're able to do that. Things will ultimately get to those people in the way that we want. However, a will, things have to go through probate. And so where I practice in California, the average cost of a home around here it's around $1 million. And the cost of probate is based on the value of what you own at the time that you pass away. So to get $1 million home through the probate system does cost $46,000 in California. You basically line up the value to, it's kind of like the tax code. So in the probate code, there's a way to figure all of this out. It's different percentages at different benchmarks, and there could be some additional costs as well. That money goes to guess who? Goes to a lawyer, goes to an executor. There can be appraisal fees and all sorts of other things going on there. So joint ownership, number one, not the best way. Leaving things in a will, especially if we're talking about real estate in California, not the best way. The preferred method, and what I advise most of my clients, is to set up a trust, a revocable living trust. We deed the home to that trust, meaning we actually file a deed and with the county records office, which is usually called the county clerk recorder's office in California, in the county where that property is. You maintain control, complete control of that home while you are alive. It is not open to creditors or predators or divorce from any kids that you're eventually going to leave things to, but once you're gone, it avoids the probate process. It will avoid any massive capital gains tax bill while they're on the deed to the home. And we can put restrictions on how they inherit things. So if they happen to be going through a divorce at the time, if they're not old enough or responsible enough to handle this home, if they are going to be at a younger age, if they're only 21, 24 years old or something, we can put age restrictions on things. If they are going through a bankruptcy or if they are being sued at the time, putting things in a trust can be a great way to protect them from these things while also avoiding the probate process. By the way, probate is also open to the public. So anybody that's interested gets to see what you had, who it's going to, how much they're getting, and in some circumstances that can leave people open to, predators or, people that have some sort of investment that they want to invest. They want your kid to invest their inheritance in, assuming you want things to go to your kids. By the way, as long as we have a trust, you can leave things to pretty much whoever you want. So those are kind of the big three ways to own things and pass them along to the people that we want when it comes to our primary residence. There are some states that have what's called a ladybird deed. Ladybird deed means that somebody else can live in the home until they pass away, and then finally it ends up going to kids. We do not have ladybird deeds in the state of California. So that's just a quick overview when it comes to a personal residence, how things can be passed on. Second, what about other real estate that you own that you do not live in? So I'm going to talk about rental properties as this main type of property. It can be commercial, it can be residential, it can be rented out by a business or, of course, by a family of their own. And it can also be owned in a similar way. All of those options still exist, plus it can be owned by some sort of a corporate entity, a partnership, an LLC, a corporation, whether that be an S Corp or a C Corp. The most common way that I see my clients own rental properties is usually in an LLC. I don't necessarily set up LLCs, always happy to point clients in the right direction. What that does is it protects our personal property from what goes on in that home. So let's say somebody slips and falls in property that you own. You want to make sure that you are not personally liable for that it's only the value of things in the LLC, basically that owns that property. We want to make sure that accounting is done properly, that we are not commingling funds and that sort of thing. So that's always a very important part of that. So that gives us liability protection by putting something in an LLC or another corporate entity. However, we still want that business because if you own a rental home, whether you think of yourself as a business owner or not, are a business owner, and that is a business, and that business has value, especially if it owns real estate. And guess what also has to go through probate? Businesses. So if we own a couple of rental properties and they're worth a couple $100,000 each, those also would have to go through probate. So what we can do is we can kind of have like a concentric circle structure. So let's say there's a rental home and that is owned by an LLC, and the LLC owns that home, and then the trust, the revocable living trust, ends up owning that LLC, that corporate entity that owns the rental property. So in some sense, things can be sort of double protected there. So it can be protected from personal liability, meaning the LLC ends up getting sued for something that happens in that home or in that rental property or commercial property. That means your personal assets, your personal home, your personal bank accounts should be protected as long as we are keeping the books straight and not commingling things. And once you pass on, it will not have to go through the probate system, and we know what all the advantages are to avoiding probate. We're avoiding the cost of probate. We're giving you control over how things are passed along and potentially from our beneficiaries, protecting them from things like a divorce, like a bank or a bankruptcy, like a lawsuit, that sort of thing. I don't think I talked about the amount of time that probate takes, by the way. In a lot of places, it takes can be in the months up to a year amount of time to get things through court and ultimately distributed. Unfortunately, in California, where I practice, I'm seeing times of around between 18 months to 24 months for something that is relatively simple, even if we're passing along a personal residence and maybe a rental property to a couple of kids. So we want to place things inside of a trust, not only to give us the advantage of avoiding the cost of probate, to make sure that we have control over things where they go when we pass away. We also want to avoid this time process of having things locked up in court, having to put out ads in the classifieds or notice in the newspaper that somebody's passed away. This is the court date. If somebody owes you money, you show up on this date and you let yourself be heard. With a trust, yes, debts do have to be paid, but it is not public. It is handled privately. That's another huge advantage to setting up a trust. So that's just a very brief overview of how we can handle real estate as part of a complete estate plan. We can own things jointly. We've talked about the pluses and minuses to that. Capital gains taxes, open to creditors of somebody else. We can pass things along by way of a will, but unfortunately that does have to go through the probate process. And my preferred way, really, for anybody that owns real estate in California or anybody that has assets that they want a little bit of control over, especially if we're leaving things to kids. Maybe we're not crazy about a spouse that they have. Maybe the kids are really young and we want somebody to watch over that money and make sure that it's used responsibly. So appreciate your time and your attention. Once again, my name is Michael Pevney. I am an estate planning lawyer in California. You can set up a time to meet with me for free by going to my website, ocestateplanlawyer.com. There should be a link in the description.